What's up, everybody? Welcome in to today's episode where we're going to talk about P. Diddy. We're going to look at some of the civil cases. We're going to read through some of the allegations. We're going to look at kind of an overview of 20 plus civil cases. We're going to talk about some of the similarities, some of the differences, how that might help or hurt their individual cases, but also how they specifically might apply to the criminal case. Additionally, we're going to look at an NDA that I believe is an attachment to one of these civil cases. It's been reported that this is kind of a sample NDA that Diddy and his team use. We're going to look at the language, see, is it sinister? Is it as bad as it seems? Will they be able to use it in any of the civil cases or the criminal cases? We're going to look into all of that to kind of give a Diddy update of all of the things that are swirling and continuing to come out. Lawsuits have been filed in October and November of this year. So this stuff is going to continue to pile on top of P. Diddy as he awaits his criminal prosecution. We're going to talk about what it means, answer all of your questions. Make sure you guys hit the like button. Thanks for being here today. Hit that subscribe button if you haven't already, and let's get into it. So the first thing I wanted to look at is a complaint, right? There's 20 plus complaints out there that have been filed against P. Diddy over the years. And what's cool about this one, or interesting, cool is probably the wrong word. What's interesting about this one is the facts are a little bit different. It's kind of shorter and to the point. It gives us an example that a lot of what's been reported in the news, and we're going to look at a lot of these cases today, and we already looked at the Cassie case, are deplorable, horrible acts, unimaginable. This one is interesting because it is a weird, creepy, illegal, should never happen act, but it's a little bit different than, the freak offs where people were forced to do things with sex workers and, ruining people's lives for a record deal. This is almost a look into how sinister and creepy and weird this really was. And if these allegations are true, how it starts to build and create the reputation of P. Diddy in this criminal case. The generally bad guy rule will absolutely apply to P. Diddy. We've talked about it in other cases about how courts will allow a lot of different information in about the background of somebody if it's relevant to the case and not just if it goes to propensity evidence. Well, these specific facts we're going to read about in this complaint today will give you a little window into that. And there are going to be some horrible allegations, and we're going to read through those, and those are going to be the headlines. But these are the types of ones that really let you know, like, something is wrong here, and this is bad. And again, if proven. And what's important when we read all of these, most of these cases are still ongoing or have been settled, but it gives you an idea of just how many victims there are and how many of them are likely going to be willing to come and testify against him in the criminal case. So that's what's interesting about seeing just the numerosity of complaints against P. Diddy. There's a lot of things we've already been through. We don't need to go through necessarily every word of the lawsuit because a lot of the background is the same as in other cases. But I do want to read some of the allegations about P. Diddy's business, right? On the surface, they seem legitimate. They have a legitimate purpose related to entertainment, music, and other subjects. Because a lot of people have asked that question. What if they're just legitimate businesses? What if P. Diddy's just making music and making a lot of money making music? That's not illegal. But in reality, Combs, by and through himself and his agents, employees, and contractors, used these businesses to assault, abuse, threaten, and coerce hundreds of individuals through sexual quid pro quo schemes, as well as take advantage of individuals with impunity, thinking the victims would never seek remorse. Combs and his agents, employees, and contractors, through these Combs businesses, would tell victims, this is what it takes to be famous. What are you willing to do to become a star? And perform this act or else, to coerce the victim into performing a non-consensual sexual act for gratification of Combs and his cohorts. So it's also interesting that a lot of these complaints will mimic and repeat some of the horrible and deplorable allegations we've heard in the media and that we see in other complaints, whether or not it all applies to their specific victim. I actually think some of the stuff that's going to be mentioned in this complaint might not be relevant in the civil case, but for public consumption, number one, and number two, to really leverage this against P. Diddy and the other businesses, to try and get a financial settlement. We're going to talk about how all of that comes into play in the criminal case. Members and associates of Combs' business engaged in or attempt to engage in, among other activities, trafficking, forced labor, interstate transportation for the purposes of prostitution, coercion, enticement to engage in prostitution, narcotics offenses, kidnapping, arson, bribery, and obstruction of justice. So again, these are things we've heard. These are some of the criminal acts that he's been charged with. But wait till you see what the claims are in this one. Horrible, deplorable, illegal. Don't forget that. I'm not minimizing them. But when you compare them to trafficking, forced labor, transportation for prostitution, engaging in prostitution, narcotics, kidnapping, bribery, it's none of those specific things. I guess it could be an element of sex trafficking. I don't know. Actually, probably not. But we'll talk about it. It is definitely a sexual offense. The Combs business constituted an ongoing organization whose matters function as a continuing unit for a common purpose of achieving the objectives of Combs. So a lot of this just is very similar language, again, to what you're seeing in other the allegations against Combs. Then we get to his pervasive history of this type of assault and violence. And to me, again, how relevant would this be? Would this actually come in during a civil case? I'm not so sure. But they lay it out nonetheless. And they go into detail about how we have the video from Cassie, about the types of parties, what they did at those parties. Talk about how he was celebrated for his business acumen, but in reality, he would use it for what? And what allegations do we have in the past? Well, we have the nightclub shooting. We have multiple assault allegations. We have business disputes. Like, what does a business dispute have to do with this civil claim? But I think, again, what they're doing is building all of it up just to show what a bad guy he is. In a normal case like this, you would not have these paragraphs. They would not be relevant, per se, to the type of case they're bringing here. Claims by Cassie Ventura. He used certain date rape drugs. He's been found guilty of criminal mischief for threatening a photographer, right? So they're just basically naming all of this. And then they go through all these other people that have sued P. Diddy. And they mention that in their complaint. Which, again, not sure what element this proves in their cause of action and why it needs to be in a complaint that you file against somebody, civilly speaking, but it's there. And again, I think this is their way to show just how bad it is. Yes, I have heard he's trying to get bail again. We'll talk about that. Highly unlikely. Highly unlikely he's successful there. Then we go into the parties. Sean Combs, Diddy's House Recordings, Inc., CEOPCO, Bad Boy Record Labels and Brands, Bad Boy Entertainment Holdings, Bad Boy Production Holdings, Bad Boy Books Holdings, Bad Boy Records LLC, Bad Boy Entertainment LLC, Bad Boy Productions. And those are the entities that they're suing. So why? And again, we've talked about this a little bit, but just to give just kind of quick answers to go through, because a lot of people asking about the civil cases. Multiple insurance policies. We have, this case, again, might just be one specific act, which is why I pulled it out. It's pretty interesting to me. But a lot of the cases where if it happened at every party, if it happened all the time, if it happened every time you recorded with P. Diddy, those could be multiple insurance policy claims. So if he has $1 million per occurrence, it's like, well, it happened on this date. That's $1 million. It happened on this date. That's $1 million. It happened on this date. That's $1 million. We've had cases like that before of abuse, especially we had a case where it was a child abuse case, horrible case that was happening at a daycare. And one happened in 2023, one happened in 2024, 2 different dates. And we were able to get the insurance company or insurance policy to apply twice. Certain circumstances, you're allowed to do that. Others, you're not. Depends on how it's written. All right. So now to the important part. The specific factual allegations of this case. Angela said, I wonder how many of these lawsuits will be thrown out. I'm sure some will. Well, that's what's kind of cool about the overview we're going to get. It's from an article. I'm going to shout out the guy that wrote it because he did a good job looking into it and what the issues are with some of them and what the procedural posture is of them, which ones are going to get thrown out, which ones are going to get which ones have already been settled, which ones are ongoing. So we're going to get into that a little bit as well, and how long some of these are going to last against Diddy. So the factual allegations of this complaint specifically: Mr. Combs' legendary white parties in the Hamptons were well known by many, including John Doe. So John Doe is the person in this case who is the plaintiff who does not want to be named. We're going to talk more about that later as well. The kind where countless celebrities would attend. In 1998, important date, right? It's a long time ago. He was only 16 years old. So this was one of the minor plaintiffs that we've heard about. He was recruited out of New York City, and indeed, while residing in New York City, received an invitation to one of Combs' party through a mutual connection. It's so weird to think like the biggest celebrities in the world, and then we have like these teenage kids that randomly come. Like, why would the teenage kids end up coming there? Like, why is it, P. Diddy and all of his friends who are, lifestyles of the rich and famous, and then we have random unknown teenage kids that are showing up there? That alone is a red flag. When he received the invitation, he felt like he finally had the opportunity to rub shoulders with the who's who of the music industry. He thought it could be his chance to break into the music industry. Others from New York City received such invitation to go to the Hamptons for the party. Indeed, many of those at the party were, in fact, New Yorkers. The party took place at Combs' mansion in the Hamptons. As John Doe entered, he spotted countless celebrities and A-listers who formed the music and entertainment industry. He recognized faces he had seen on TV and on the big screen. As John Doe made his way through the crowd toward the restroom, he unexpectedly bumped into Combs. Shocked, John Doe found himself face to face with Combs, a titan in the music industry, standing right in front of him at his own party. Doe took a picture with Combs at the 1998 party. And here's the picture. Now, something a little strange I found about this is he's going by John Doe, trying to keep his anonymity, which I'm all for if it's appropriate. I wonder why they put this picture in the public document. I realize they blurred out his face, but I don't know why they would have just held this picture back or filed it under seal or given it to the other side and not put it in the public document. That's kind of weird for me. The face is not the only, identifying characteristic, but regardless, it's there. So now here's the creepy stuff. Combs took an interest in John Doe and wanted to talk to him. They walked to a more private area near the portable restrooms brought in for the party. There, John Doe told Combs he was a big fan of Combs and shared his dreams of becoming a star. Combs smiled, telling him he had potential and the look. When John Doe admitted his voice was not great, Combs assured him that did not matter. Combs made clear that the only thing that mattered was having the right look for the industry, and with it, Combs could transform Doe or anybody into a star. All sounds plausible, right? Despite the pleasant conversation which occurred, things took an unexpected turn for the worst. Combs abruptly told John Doe that he needed him to drop his pants. John Doe, caught completely off guard, confusingly asked Combs to repeat himself. Combs made himself clear. He instructed John Doe to drop his pants and expose himself so that Combs could inspect his manhood, explaining it was a rite of passage and the route to becoming a star, and also as a way to prove himself. Don't you want to break into the business? Doe immediately felt uncomfortable, froze, did not know what to do. Combs remained calm and stood in front of him and stretched out his hand in a cupped position. Out of fear, anxiety, and the imbalanced power dynamic between himself and Combs, John Doe then dropped his pants and exposed himself as Combs previously instructed. Combs moved closer, grabbed John Doe's package with his hand. He firmly cupped and held on to John Doe's genitals for an extended period of time. During this time, Combs moved his hand in such a fashion to manipulate John Doe's genitals, squeezing and feeling them. Doe was only 16. Combs abruptly then let go of John Doe's genitals and told him his people would be in touch. Combs continued with the party as if nothing happened, but for John Doe, everything had changed. John Doe eventually recognized Combs. He assaulted him by and through his power and influence over John Doe because he knew John Doe wanted to become a star. As a result of Combs' assault on John Doe, while he was a minor, John Doe experienced damages including pain and suffering, mental anguish, physical impairment, and emotional torment. The interaction continues to humiliate and cause shame on John Doe. Because of Combs' power and notoriety, plaintiff was afraid to report what had happened. John Doe became yet another victim of Combs through the same pattern of abuse of influence Combs exercised over others previously. Okay. So this is deplorable. It's horrible. It's abusive. It's taking advantage of a minor. It's using your power. It's manipulating him. I found it interesting because so many of the other complaints and issues had to do with these freak off parties, right? And what happened with them and the baby oil and the prostitutes and workers and, everybody and, forcing each other, people to do stuff in front of Sean Combs while he, pleasured himself. We're going to hear all sorts of horrible allegations here in a minute. But I thought it was interesting that this is another complaint. This is also something that the feds can evaluate. This is also something that the feds can have an attachment to him doing this to minors. So even though it is different acts, it still could allow the feds to have even more superseding indictments and charges coming against P. Diddy. And we could easily have some minor charges based on this specific action. And it could all fall into the RICO. It can all fall into just more deplorable acts for Sean Combs. So we talked about 1998. Let's talk about what the cause of action is. What are they suing for? Violation of the New York City Victims of Gender-Motivated Violence Protection Act. Plaintiff hereby incorporates each of the foregoing paragraphs as is fully set forth here. By forcing this kind of contact onto the plaintiff as a young male minor, defendant Combs committed a crime of violence motivated by gender under the Victims of Gender-Motivated Violence Protection Act, as defined in New York City Administrative Code, Section 10-1103. The requirements that the crime of violence be committed because of gender or on the basis of gender and due, at least in part, to an animus based on the victim's gender is satisfied because defendant Combs forced plaintiff to engage in this interaction without consent. So I guess, and it's different, like you would think if it was a hate crime, there's got to be some nexus where they prove it had to do with somebody's, race, religion, creed, whatever it may be. And here, the fact that it has to do with the victim's gender, they're saying that's proven because it was done without consent. John Doe could not effectively consent because of his age. The non-consensual touching of a minor herein presented a serious risk of physical injury and, in fact, caused such injury. Gender animus inheres when consent is absent. Moreover, Combs' long history of violence and sexual abuse against men evinces a deep contempt and desire for domination over men. So he's saying this proves he targeted men. He wanted to do this to men, to boys, to minors, and that's enough for this act. I don't know. I've never filed a claim under this act. I've never filed a complaint under this act. There are plenty of assault, battery, abuse of minors. There are plenty of civil causes of action you can file for something like this. But if you remember, in New York, they have a 2-year clawback for this exact statute. So this statute allows something from 1998 that may or may not be outside the statute of limitations. It gave them a 2-year window, which I think ends February-ish of 2025. They had from like February of 2023 to February of 2025 to look back and say, hey, now's your chance. You got 2 years. If you are a victim, come forward now. This might be your last chance. File whatever claim you got to file. We're extending the statute of limitations. And that's why, I believe they're fitting it under this act. The Combs business enabled Combs to commit the crimes violence motivated by gender because Combs assaulted the plaintiff at a party related and referencing to Combs' business on information and belief. I bet you, so here would be an interesting thing, right? If they're going to prove how the businesses are involved, did he write all these white parties off, right? Is all this stuff business? Private jets and, all of the whatever shenanigans that you did, mingling with other entertainment industry folk. It seems like a legitimate write-off to me. So that's going to be things that they can start to use, that these were obviously business parties, and bringing the businesses into these claims can definitely help with if Combs has no money left or if all of it's locked up or seized or whatever it may be or frozen, the insurance policies of these companies absolutely can stand in the shoes and pay whether or not Combs has money personally. And that's why they're trying to attach the businesses to these civil lawsuits. To further the business purpose, he has a longstanding pattern of practicing committing these kinds of violence. Again, they should have known basically that he was doing this. His business enabled him to do this. Let's see what else we have. As a result, they suffer damages. That's always important. The legal action has been commenced within the statutory time frame provided by the 2-year look-back window of this claim. All right, so here's the other thing. So what are they looking for? Well, they're looking for compensatory damages for physical injuries. That's, any pain and suffering, emotional distress, lost wages, loss of earning capacity where you're not able to go, do your career because of this. Did you have any medical bills, any mental health bills, things like that? Punitive damages, damages to punish. Now, what's interesting about this, most insurance policies do not cover punitive damages. They also don't cover intentional acts. So it would be interesting, and I have to do the research on this. I actually don't know the answer to this. But if this is considered an intentional act and the insurance company doesn't cover, the insurance for the business doesn't cover intentional acts, and they were some kind of either negligent supervision, negligent hiring, and they were going to have to file under that. And if that would be the negligence, statute of limitations has run. So would they not be able to file those negligence claims against the businesses in order to hook the insurance? That's an interesting legal question as far as how this look back works with businesses and not just with people personally. I'd need to do more research on that. Okay, punitive damages, attorney's fees, costs, interest, and attaching any of his real property. They're going for everything. And Tony Busby, this was one of the victims that he referenced in his press conference, and no surprise, he's followed through with a lawsuit. And because he's filing so many of them, again, they're not class actions, I would be willing to bet that pages 1 through where is the factual allegations? 1 through 13 is probably eerily similar in most of the cases he filed, at least in New York. It'd have to change a little bit as far as, jurisdictions and statutes that you mentioned. And then, of course, what you file under and all this stuff will be different depending on where you're filing it. But I would be willing to bet that that is probably eerily similar in most of these complaints. Okay. So since we've looked at 1, let's take a second now and read through. Where is it here? I don't know why it's not letting me pull up. Guess I could do it this way. Not ideal, but all right, we'll do it this way. All right. So this is not ideal, but for some reason, I can't share this PDF otherwise. All right, here we go. Here's an example of the NDAs. Oh, this is annoying me. All right, we're going to read it. So if you guys can't read it, it's okay. This confidentiality agreement is made and effective as of Friday, September 9th, 2022, by and on behalf of, and things are obviously going to be redacted out. So the goal of reading these, right, and the reason I wanted to read these is to give us an idea of what was and was not hold on. So one of the goals of reading through these, right, and reading through this NDA is people always assume the sinister things in NDAs, like all of the freak offs, you can't talk about that. All of the criminal activity you see, you can't talk about that. And usually they're much more toned down than that. They're much more broad. Lawyers write these in a way so that we can argue later anything could be subject to this NDA, right? You give a phone number, you take a picture, you tell somebody you were there, and we could potentially say it was part of this NDA. Of course, mentioning criminal activity and things like that, we will argue has to do with the NDA. And you would lose because NDAs are not going to protect anybody from keeping somebody from talking about or calling the cops or ratting you out for criminal activity. People are asking if it's a specific big pop star. I don't think that's him. I have no idea, though. I have no idea. I don't know, so I don't want to guess. Okay. The term you shall include you, your estate, each corporation and or other business entity in which you have an ownership or beneficial interest, and any and all persons and or entities owned and or controlled by you and or such businesses, affiliates, employees, officers, directors, managers, accountants, and agents, and all of your respective heirs, executors, representatives, administrators, employees, licensees, successors, and assigns for good and valuable consideration, collectively consideration, the receipt and sufficiency of which are hereby acknowledged by you and hereby irrevocably agreed to as follows. So it looks like the amount of money, because consideration is the amount of money that they pay for you to shut up, for you not to speak, for you to not disclose. And the consideration here is blotted out, but this is the amount of money you're agreeing to. Now, what you'll notice about this first paragraph, which I find very interesting, right? And this stuff may be into the weeds. So if you guys, are bored with it, just let me know and I can move on. But if you notice from the first paragraph, it's like everybody you've ever talked to, worked with, anybody that's in your family, dependents, people you might leave in your will, everything and everyone that could ever possibly find out about this information, if they leak it, we're coming after you for this money. Now, that's nearly impossible to enforce, because if my employee, right, if I go to this party and I sign, right, my employees here at the office, how the heck are they going to know that I signed an NDA? Now, you would think you shouldn't say anything where your employees here, sure, but if they do hear and then they go out and talk, well, now they're going to come after me for something my employee said. So they're trying to get every single person that could ever possibly come into contact with every single person that has ever signed an NDA to spread it like wildfire, to keep everybody quiet, to try and touch everybody they possibly can. Now, many times there's difficulty in enforcing quite as far as this reaches, but it's also not so different than many releases. Like, we've read some releases before together, right? And releases happen in most civil cases. And this is really not unlike what's in a lot of releases, right? Confidentiality agreements. So when we think it's automatically sinister because there's an NDA, that's not always the case. Sean Diddy Combs, aka Puff Daddy, artist, privacy is highly valued, and all efforts will be made to maintain confidentiality with respect to all information and other material of any kind, including without limitation to the terms, conditions, or existence of this agreement. Always important. The existence of an NDA has a negative connotation, and therefore we want to make sure that nobody even knows it exists. Where was I? Concerning and or related to directly and or indirectly artist and or any person, corporation, and or other entity related to or affiliated with or associated with artists personally and or professionally, including without a limitation, family members, relatives, past or present, fiance, fiancés, husbands, wives, boyfriends, girlfriends, friends, and business associates, collectively artist parties, and each artist an artist party. So what they mean by artist party is not like a freak off party. They mean like a person, a party to a lawsuit. Except for information or material publicly and intentionally disclosed by the artist. So it's like, if he posts it on Facebook, if he films it and puts it on YouTube, sure, then you can talk about it, whatever, but not this specifically. And you notice, as broad as it is for the person signing it, they want to make it that broad for P. Diddy, the defendant, the person protected. You shall not at any time use or disclose directly or indirectly to anyone any of the following information, any information acquired by you in any manner and or by any medium or means whatsoever at any time in the past, present, and or the future, which concerns or in any way relates to artists, any artist parties, or any artist business entities, entertainment activities, financial affairs, personal life, and all information shall be deemed confidential, private, secret, sensitive, and kept by you as confidential information shall be deemed confidential, private, secret, sensitive, and kept by you as confidential unless the artist otherwise advises you in writing, in artist's sole discretion, any and all information described in paragraph 1A, including without limitation, pictures, recordings, records, documents, property, merchandise, or other information related to artists and or personal, professional, and or other activities of artists or any artist party, whether prepared by or on behalf of you or otherwise coming into your possession, is and shall remain artist's sole and exclusive property and shall not be disclosed, removed, sold, disseminated, copied, or otherwise used and or exploited by or on behalf of you without artist prior written consent, without limiting the foregoing, without artist prior written consent, which may be withheld for any or no reason. You shall not and shall not authorize any third party to photograph, film, or otherwise record, but he was allowed to, it sounds like, any sound, likeness, and or activities of artists and or any artist parties of any kind or nature, whether personal, professional, or otherwise, including without limitation in the appearance, performance, and rehearsal by artist, or and or any other activities during or related to the service or activity performed by artist or any other artist parties without limiting the foregoing. You shall not and shall not authorize or facilitate any third party to without author's prior written consent, give any interviews, write or prepare or assist in any preparation of any books or articles, make any remarks of any kind to the media, to or for use by yourself or any other third parties. Let's see, whether or not publicly disclosed, you hereby irrevocably grant, convey, transfer, and assign to artists all worldwide right, title, and interest, including all copyrights and any renewal in any to any prohibited, let me see, how do I get to page 2? There's page 2. Material, whether or not the same are used and or exploited, and regardless of the medium involved, and artist may register such copyright in his or her name. So basically, he owns everything. He owns everything, right? Nobody has a say but him, and that's how he wants it. All right, keep reading here. Artists may register some copyright without limitation of any remedies. We already read that. Artist parties shall be entitled to recover any and all monies or other benefit whatsoever received by, on, or behalf of you from any and all sources in connection with or any use, dissemination on behalf of you, confidential information, prohibited material under, and any such monies or other benefits so received by or on behalf of you shall be held in trust by or on behalf of you for immediate payment to artists and or artist parties. You shall not and shall not authorize or facilitate any third party use and or reference an artist or artist party's name or identity, including a relationship with the artist and or any artist party with respect to any transaction, sale of goods, or other solicitation, and without limiting the foregoing. You shall not at any time defame or disparage artist and or the artist parties and or use, disclose, disseminate, or confirm directly or indirectly to anyone any information or material which may harm, disparage, demean, or reflect negatively or poorly upon or cause injury to the reputation, character, or career of artists or any of the artist parties. So this here is an indication of what somebody may be afraid of if you wanted to rat out P. Diddy, right? You wanted to tell your boss, your mom, your dad, the news, law enforcement, anything about what happened at one of Diddy's parties. That section about non-disparagement, not doing anything to harm or hurt him, not doing anything to hurt his career, that is the section that might scare you. Louise said, lawyer, do you think lawyers writing these NDAs know what was going on? So here's what I will say. I don't know because I don't know these particular lawyers, but I will tell you, absolutely not do most lawyers know what every single one of their clients, especially famous clients or wealthy clients, are doing at all times, right? I have written lots of NDAs for people, especially like professional athletes or people that, have people coming and going or working for them that they don't want to take pictures of them or to work for them and then go say, oh, he was a bad tipper or whatever, stuff like that, right? And they usually pay people to not go do stuff like that so they can just relax and live their normal life. Now, could this be going on in the background and in the basements and in the pool houses at their house? Maybe, I don't know. This is not like a question that a lawyer asks, oh, okay, what are you going to be needing this NDA for? What are you trying to protect? That's not a necessary legal question to ask before writing an NDA. And that's also why I'm reading this, right? You can understand. Let's take P. Diddy's case out of this just for a second, okay? You can understand as we read this, and that's why I want to read through this. It can be a little bit boring. I understand that. It's a little dry reading through an NDA, but some of them actually tell me exactly what they're using it for, and it's completely appropriate. But you can see and read this and understand how a completely normal person may want somebody to sign an NDA, right? Like how nothing necessarily illegal is going on and you still want to sign an NDA because you're famous and you're worried about getting used. And you don't want somebody to go sell a story because you were able to go to, I don't know, who's a celebrity. Somebody just said, oh no, I don't want to guess who the person is, but if you go to some celebrity's party and they make you sign this and nothing weird happens, but what they don't want you to do is go call TMZ and say, hey, I was just at this party. Guess who was there? This is what we ate. He was really cheap, etc. Like, you can understand why certain celebrities want people to sign NDAs before letting them into their life in a lot of different situations. But that's exactly why. And that's the public policy behind the fact that this does not stop somebody from calling the cops if this happens to you at the hands of P. Diddy. And that's why that has to be really important. That the appropriate use for this is not to allow people to commit crimes, to victimize people, and then to not let them call the cops. Now, some could say, and I actually think you'd have a better argument, that a release on a settlement document when you file the lawsuit is a lot closer to that, right? And people feel that way even more. And sometimes people even inappropriately agree to not call the cops then afterwards. It's supposed to be completely separate, to be kept completely separate. But let's finish up. I think we're about halfway through it. The foregoing expressly includes, without limitation, communications appearing on the internet via blogging and or social media sites such as Facebook, Twitter, and Instagram. That shows you how much smaller YouTube was just a couple years ago, right? It wasn't even mentioned here. Without limiting the foregoing, you shall not, without artist permission, distribute, publish, or permit to distribute or publish photos, videotapes, films, audio tapes, and any other recorded sound or image or any other materials of artists and or artist parties. Copy, except as otherwise, use and or dispose of any artist or artist parties material, including any property or materials in your possession that belong to the artist or the artist parties. Upon expiration or termination of the relationship with or in connection with the artist, you or your legal representative, heirs, successors, or assigns shall promptly deliver possession to artists in good condition any such property of artist and or artist parties or other records, copies, excerpts, and other aforementioned materials that are in your possession or control. You acknowledge that due to the nature of the entertainment industry, any disclosure or dissemination by you of any information or material described in paragraph 1 will deprive the artist and or the artist parties of the right to use such information or material. So you see a couple things in here, like you agree right now that P. Diddy will be damaged. You agree right now that they'll lose out on the opportunity to make money this. You agree right now that if you violate this, you are hurting them. And the reason for that is they don't want people to be able to come later and say, oh, I didn't do this, I didn't do that, he wasn't actually hurt. It's like, well, you signed a document that already said you hurt him, etc., for doing that. So that's why a lot of that language is in there. You expressly agree that if you breach or threaten to breach paragraph 1, they'll suffer immediate irreparable harm and injury which could not be adequately compensated by an award of monetary damage. In addition to all other rights or remedies available to artists and or artist parties, they shall be entitled to injunctive relief and all other remedies provided in such event by law or equity. That's like if you are posting videos or you make a movie or whatever, they can stop you, pull it off the internet. That's injunctive relief to stop. They can also get monetary relief by taking your money back. These are the threats and the scares and the leverage that you get when you do an NDA with all this language that's very long, written by an expensive lawyer. Such remedies shall include, without limitation, the right to prevent dissemination of any information or materials described above. You agree to execute any documents and take such other actions as may be reasonably requested by artists and or the artist parties to further evidence or effectuate the rights set forth in this agreement. You hereby appoint artist as your attorney in fact. I mean, how about that? With full power of substitution and delegation to execute all such documents which you fail to execute within 5 days of the arrest and or any parties or artist parties request thereof. So that's another thing that's almost impossible to enforce, especially if you have a legal reason not to do it, or you have a dispute as to whether or not it even fits into this. But to a normal lay person, that is scary language. Like, what if I do this? He has power of attorney. He can go start signing documents on my behalf. Some people think this means he can take the money out of my bank account if he's your power of attorney, which is not what it's saying. Sorry. It's not what it's saying at all. But scary. Can be really scary, right? Not illegal, but scary. The term of this agreement and duty to keep all information confidential and not published material shall commence on the first date above and continue for the life of the artist. So for P. Diddy's life, not just life, plus 20 years. And you can imagine the reasons for that, right? Old news, nobody will care. He's been dead for 20 years, right? or 70 years, whichever is longer. So if P. Diddy lives another 90 years, then that would be longer. You warrant and represent that. And by the way, you realize that most likely the person signing this, it might not be alive either in 70 years. If you were a betting man or woman. You warrant and represent that you have full right, power, authority to enter in this agreement and be bound by the obligation herein. By the way, in most states, minors cannot sign contracts. So it may actually be unenforceable if a minor signs a document like this, even if you say, I have the right and power to sign this document. Neither the execution, delivery, nor performance of this agreement by you shall conflict with or result in a default or loss of rights under any agreement or understanding to which you or any of your affiliates is a party or by which you or any of your properties may be bound. This agreement constitutes your valid and binding obligation enforceable in accordance with its terms. You have signed this agreement voluntarily without duress, coercion, or undue influence. Like you're agreeing that I'm not forcing you to do this. You're agreeing I'm not scaring you to do this. So sign right here or you can't come to my party. It's like, and again, that's why even when you sign this stuff, if I were to go through this, I could probably pick out 25 different reasons I think this is unenforceable. And I could make 25 different arguments against this. The terms, the one-sidedness, the duress or coercion that might be involved, the unenforceable nature of what it's asking for, maybe limitations on First Amendment issues, definitely doesn't protect from unlawful activity if it's a minor entering into this without knowledge or consent of his parents. I mean, there are so many arguments you can make against a document like this. But do you know why people do this? A lot of times it's just a scare tactic. And if 1,000 people sign these NDAs, the vast majority of them are never going to do or try anything because they signed the NDA, whether or not it is enforceable or not. And so when people are doing illegal, horrible things, this is a dangerous and pretty bad tool. But that's why, in the interest of justice, sometimes they are unenforceable. Karen asked if this is a typical NDA or is it sort of extreme. I would say it's a very in-depth NDA. And it's specific to P. Diddy and being an artist and being at his parties, things like that. Every NDA is a little bit different depending on what your situation you're in. But I don't think it's that atypical. I really don't think it's that atypical. I think it's pretty normal for an NDA. Like if you're going to do an NDA, right? If you're the type of person to do an NDA, you're usually going to do it like this. You're not going to do an NDA that's like, please don't say anything bad about me. Here's $50, sign the bottom here. You're usually not going to do an NDA, right? Okay, let's see. You have signed this agreement voluntarily without duress, coercion, undue influence. This agreement shall be deemed to have been entered into in the state of New York, and its validity, interpretation, and legal effect shall be governed by the laws of the state of New York, applicable to contracts entered into and performed entirely therein. New York courts only will have jurisdiction over all controversies regarding this agreement, and any action or other proceeding which involves such controversy will be brought solely in the courts located within the state of New York. You hereby consent to the personal jurisdiction of such court and waive any objection based on personal jurisdiction, venue, or forum nonconvenience. This agreement embodies our entire agreement with respect to the subject matter hereof. This agreement shall inure to the benefit of the binding and be binding upon the parties hereto and their respective heirs, executors, administrators, representatives, members, owners, shareholders, licensees, designees, successors, and assigns. This agreement may not be transferred or assigned in any manner by you, or any attempted transfer or assignment shall be deemed null and void. Faxed photocopies and scanned signatures of this agreement shall be deemed effective as originals. You agree to defend, indemnify, and hold the artist and the artist parties and their respective parents, subsidiaries, affiliates, licensees, assignees, and their officers, directors, members, managers, agents, distributors, and employees harmless. So this is what we call a hold harmless agreement. And he's including everybody, right? People that aren't even there, people you don't even know, okay? The other businesses. So you're going to indemnify them and hold them harmless. That means if they do something horrible and people come and sue them, or if somebody finds out you're at a party and they sue you because you're at a party, or something happens that you are involved at all with this connection with this person, you're going to take the heat. You're going to hold them harmless. You're going to indemnify them, meaning potentially pay the money that they might owe. Hold them harmless from and against all liabilities, damages, judgments, losses, costs, and expenses, including without limitation, reasonable counsel fees of any kind or nature whatsoever, which may be sustained or suffered by or secured against any of them by reason of, based upon or relating to any breach of any of the provisions, representations, or warranties contained herein, or by virtue of the inaccuracy in a breach of the representations and warranties made by you hereunder to any third party on behalf of the artist and or the artist parties, or any claim, action, or proceeding asserted or instituted relating to or growing out of any such breach. So let me just give you an example of how this could play out, okay? Let's say you're this 16-year-old kid. This happens to you. You have a buddy that goes there that gets trafficked. They bring in, the sex workers, and he's got to do this stuff for Diddy, and all this crap happens to him, right? And you want to tell somebody, and you want to sue, and you get it together, and you get him, and you're like, let's go sue. And then you send a demand letter for money to P. Diddy, and P. Diddy's lawyer sends you this back. Hey, you agreed to indemnify us and hold us harmless. And because you leaked this information, that's now going to cost us money, and we're going to have to pay damages to your buddy because this happened to him. We're coming after you to indemnify us based on paragraph 5. Now, guess what? In no world, I shouldn't say in no world ever, right? I never say never or always. That would be highly, 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 highly unlikely to ever happen or be enforceable in America. And I know that. But does 16-year-old John Doe know that? Does Little Rod know that? Does Cassie know that? Do all these people signing these NDAs, and I don't know, which of them did or didn't sign NDAs, but do they know that? Or when a lawyer writes them back and shows them that paragraph, are they scared into silence? Now, you would think if they're going to sue P. Diddy, they have a lawyer, and the lawyer would be able to tell them that it's okay, don't worry about it. That's clearly not going to happen. But that certainly is what it can sound like when you read this. All covenants, terms, restrictions, and provisions of this agreement are severable. If any such covenant, term, restriction, or other provision is held in court to be by a court or other legal forum of competent jurisdiction to be invalid, void, or unenforceable, such covenant, term, or restriction shall be amended to the limited extent necessary to be valid and enforceable, and the remainder of the agreement shall remain in full force and effect. So what that means is, like, let's say paragraph 5, somebody said that's not enforceable. Well, what they're saying is that's fine. We will remove paragraph 5 and the rest will still be enforceable because you signed it. No, if they signed it, they are not screwed, Kathy. No, they are not screwed if they signed it. It's not going to have a big legal effect on a lot of these cases, is my guess. Okay. This isn't, and obviously when somebody said, hey, remember this? Yeah. And obviously when you say remember this, they don't, because they were like, oh, I get to go to Diddy's party. Yeah, I'll sign right here. What else do I need to sign? I'll sign anything to get into Diddy's party, right? All right. Let's see here. This is an impartial legal document. You acknowledge that you have reviewed this agreement with your legal counsel or knowingly declined the opportunity to do so. Your failure to review this agreement, your legal counsel shall not impair the legally binding nature of this agreement, and you have fully read and understand and voluntarily accept all the terms of the condition of this agreement. You certify you're 18 years of age or older, accepted and agreed, including acknowledgement of receipt and all consideration. So if you're 16 and you sign that you acknowledge you're 18, guess what? It doesn't make you 18. Doesn't make you an adult. Doesn't fix the problem. Additionally, most NDAs, the best practice is to say, take 3 days. Take 3 days, whether you're going to talk to a lawyer, whether you're not, think about it, whatever it may be. My guess is that didn't happen here. I don't know. Okay. That's it for the NDA. We're a little late here in our video, but I do want to read through at least some of the other allegations from the other cases. And I'm going to post the article up here. So this is called A Guide to the Diddy Lawsuits. Okay. And they kind of go through it. It's pretty interesting. Ashley said, if you aren't collectible signing an NDA, though, not much they can do if you break it, right? Well, so here's the thing. And here is, again, where the ticket is. And sure, we can talk about Zach Bryan, the alleged NDA that he was going to have his girlfriend sign, right? His ex-girlfriend. They break up. Story goes, he was going to give her $12 million. She was not going to be able to disparage him. She was not going to be able to do X, Y, or Z. Okay. Well, she's collectible, so maybe not a good example, but this will give you give you your answer, I think. Even if she was uncollectible, even if she had no money, even if she was not a podcaster or whatever, she is a social media influencer. What he does is, if she writes a letter, if she writes an email, if she goes on YouTube, if she posts on Twitter, Zach Bryan did X, Y, and Z to me. Even if you have no money, they're going to come looking for that $12 million. So that's why finding an amount of money to get somebody to sign an NDA is at least usually enough money that they don't want to lose it later. And if they're uncollectible, so Ashley, it's, I would say you're not a person of average intelligence. I would say you're above that, as I would say a lot of people in the chat are. And even the way you're asking this question lets me know that you understand what it means for somebody to be collectible or not collectible. People don't usually look at themselves as uncollectible. They don't usually say, forget it, I'm going to break this so somebody can come sue me because I don't really care. I have nothing to take anyways. People generally don't want to lose the money in their bank account. They think they can lose their houses, even though in a lot of states there's homestead exemptions. They don't want to have their wages garnished, even if there's not a lot of money there. They don't want to have their credit hurt, right? Somebody gets a judgment against you. They send it to collections, even if it's from an NDA. And now that's up against you. You can't get a credit card, buy a car, do all sorts of things, right? So generally, people don't want to take that risk. But what you're saying and what a lot of lawyers tell people is you're uncollectible. Exactly what you said. And so if you are and they didn't give you any money, then that makes the NDA even more worthless. But let's say you are not a social media influencer, but you go on YouTube and you start to talk about your experiences that you sign an NDA. Well, now they're going to get those videos taken down and maybe get any money you made off those YouTube videos or social media posts or whatever it may be. So you still have something that you might be losing. And in a legitimate scenario, let's talk about a legitimate scenario here, okay? You go to Aretha Franklin's house. She has you sign an NDA because she wants privacy for her friends, right? And she gives everybody $500 that signs the NDA, whatever it may be. And somebody goes on, takes pictures, posts them online, sells them to TMZ about Aretha Franklin and her friends. I tried to pick a celebrity that people would not think was having a nefarious party. That's why Aretha Franklin popped into my head, just in case anybody's wondering. Well, that's annoying, right? And she can collect that $500 back. She could get those pictures taken down from TMZ because of the NDA, and she can take whatever money was paid to you by TMZ for you violating the NDA. So it gives her some legal power to protect the privacy of her and her friends in her house, at a dinner party, whatever it may be, right? That's kind of how it's supposed to work. Some of them I've had NBA athletes that have had people sign NDAs that work in their houses, that are there every day, that might, and they're a single guy. And, I don't necessarily condone everything everybody does, but they may have different women over from time to time. They may have friends over. They may be drinking certain things or doing certain things that maybe wouldn't be good for their public image. And maybe if somebody is a housekeeper or a pool guy or the lawn person or whatever it may be is coming around and they're like, for this contract, you have to sign this NDA. If you don't want to sign the NDA, that's fine, but I'm not going to hire you to do this work. You may see a celebrity come in that I'm now in a relationship with and I want to keep it private. Legitimate reasons to have an NDA, right? And so there are not all nefarious and evil reasons to have an NDA, and you can understand how some of that language makes sense that way. Yeah, Karen, from my perspective, if I ever write an NDA for somebody, I want them to attach money to it. They don't have to, it's their prerogative. But I'd be like, attach some money to it so they don't want to violate it and break it. There's no money attached to it and they're just a random person, coming to one party. It's like, okay, take your chances. All right. Okay. So Rodney Jones, this is Little Rod, filed the lawsuit in February 2nd, 2024. It's ongoing. The lawyers have accused Combs of harassing behavior, including manufacturing stories about plaintiff on TMZ and dispatching his agents to harass plaintiff's 8-year-old daughter, mother of his child, ex-spouses, all of whom have expressed fear of potential harm by defendant Combs. Jones' attorney told Judge Paul Oetken, who is overseeing the case, that an additional police report had been filed on March 3rd. Jones is asking the court for a jury trial. Combs' response, when reached for comment, Combs' attorney provided a near identical statement. Mr. Jones is nothing more than a con man, shamelessly looking for an easy and wholly undeserved payday. It said, we have indisputable, incontrovertible proof that his claims are complete fabrications. Our attempts to share this proof with Mr. Jones' attorney, Tyrone Blackburn, have been ignored as Blackburn has refused to return our calls. We look forward to addressing these ridiculous claims in court and intend to take all appropriate action against all who are attempting to peddle them. So we're going to read through some of these again. And the point of this is to look at how many different civil claims are being made, what Combs' response is, to think about if any of these or which of these end up being victims in the criminal case. Because if you remember with R. Kelly and so many of these different cases, not all of the civil claimants end up as criminal victims. Either they couldn't prove their story, they weren't found as a credible witness, there were issues with their story, maybe they have some kind of a background that makes it not worth the prosecution taking the chance to put them on the stand. There's some strategic lawyering going on when it comes to picking which victims are going to be your victims in criminal cases. And Diddy's responses in a lot of these, you'll see, I mean, this was before the federal charges, the criminal charge were filed, adamant, I didn't do anything I can prove against you. So that kind of opens the door to, will his defense be, I can prove all of these are false? And also keep in mind that every civil plaintiff that has filed a lawsuit, usually the courts, the criminal courts, are going to allow the defense to use that civil lawsuit as impeachment material to go to show that that person is biased. They have a financial interest in this case because if Diddy gets convicted, they get money. So can we trust them? Can we believe them? They are looking at a payday. That's what they want. So they're going to come up here and they're going to say whatever they can say to get a payday. That's how criminal defense attorneys can use these civil lawsuits. Sorry, I was trying to catch up on the chat there for a second. John and Kelsey, you can start some questions if you want as well as I'm reading through these because I want to get some questions too because we only have about 10 minutes left maybe. Okay, Jane Doe. Allegations are horrible. I'm not going to read them all, but you can see here, I'll leave them on the screen as I'm kind of explaining how each one is going to affect the case. Okay, and you can kind of see what the allegations are for some of these. Filed December 2nd, 2023. Ongoing, they denied the allegations. Attorneys have asked the judge to dismiss the entire case. It's all about cancel culture. I mean, how cringy are some of these responses now that there are federal charges, right? Presumed innocent. Nothing has been proven. But it does take it to a second level now that it's not just people looking for money, but the feds are also looking into it and have found enough to file charges. Because we have to remember, civil lawsuits not beyond a reasonable doubt. It is more likely than not, greater weight of the evidence, kind of similar to probable cause, right? So now the feds and assumed unbiased third party have looked into some of these allegations and they have found there is probable cause. So that's kind of more akin to civil lawsuits. Combs' response, enough is enough. I've sat silently, watched people try to assassinate my character, destroy my reputation and my legacy. Sickening allegations have been made against me by individuals looking for a quick payday. Let me be absolutely clear. I did not do any of the awful things being alleged in the lawsuit. Those are public denials. And if they're coming from P. Diddy, they can and will be used against him in criminal cases. Never participated in, witnessed, nor heard of anything like this. These disgusting allegations are false and desperate attempt for financial gain. I will vigorously protect my reputation. So you would agree that they're disgusting allegations, right? Cassie, we know about her. And one day after the lawsuit was filed on November 16th, settled on November 17th. And we talked about her lawsuit. Liz, Again, allegations very similar, very horrible. A lot of what was alleged in the federal criminal cases. And again, you'll see, so the New York Adult Survivors Act, that kind of safe harbor of when they could file it ended, I think they said a day after this. So like November 24, 2023. So that's why we're seeing some different causes of actions happen now for different protections to get past the statute of limitations. It's ongoing. And he said fabricated and bogus. Joy Dickerson, again, you'll notice this date is important. Everybody was trying to get their lawsuits in prior to the end of that extension. It's ongoing. They're filing papers, responding in discovery. And this just also gives you like the vast number of issues and cases P. Diddy and his team and his businesses are dealing with at this point. He recognized it as a money grab. Okay, Grace, April 4th, 2024 in LA. It's ongoing. So this one includes his son. Same kind of manufactured lies we've seen before from this attorney. And again, we'll see similar attorneys, similar causes of action. Once you write the playbook, you get more players and you go. And it becomes an army. And the more you have, the more leverage you have, the more pain you can inflict on the wrongdoer. Because these people obviously believe P. Diddy is the wrongdoer in this situation. Jana said, did he use the NDAs with people who may not have known they could be broken? Absolutely. Those are usually the most effective people that if you're trying to assert dominance and power over, that's what you would do it to. If your client brought this NDA to you seeking your advice, would you okay them to sign? So usually I don't say, yes, you should sign this NDA or no, you shouldn't sign this NDA. So I don't do a lot of this work anymore. I used to do a little bit of it. I write some once in a while. I don't like advise on legal documents very often. I like to stick to what I do, right? We have a lot of cases that take our attention and time, wrongful death cases, car accident, truck accident cases, the criminal defense cases that are in our firm. So I don't do a lot of these like one-off things, but when I used to do more of it, or if I do it for a friend or something like that, I don't ever say, yes, you should sign this. This is a great document to sign. What I do is I'll write them an email saying, here's what this paragraph means. Here's what this paragraph means. Here's what you're waiving. Think about X, Y, and Z. Is this worth it? Could this happen to where you could break it? And if you do break it, here's what you're looking at. So that's usually what I'll explain to them. I don't usually say sign it or don't sign it. All right, this one was filed May 21st, 2024, and they haven't responded. You'll notice not as many responses in the more recent 2024 cases. April, another May of 2024. Derek, June of 2024 in Michigan. The judge has set aside the $100 million judgment because the notice of the case was not properly sent. There will be another hearing. So I don't really know procedurally what's going on in this case, but it looks like Diddy did not respond. And so if you don't respond in a civil case, you can go forward and you can get a judgment, which means there's no defendant sitting there. The plaintiff can show up, explain to the judge, present their evidence to a judge or a jury, get the jury to give them a verdict, which this one was a $100 million judgment. And you say, boom, I just won $100 million. Now you go try to enforce that judgment against the civil defendant. And you say, you owe me $100 million. Here's my judgment. The issue is, and it makes sense, and Diddy's got a pretty good argument since he's responding to a slew of other cases that you did not properly notify him. And if you don't properly notify a defendant, you're not just going to be able to sneak a judgment by, not let the defendant defend himself, and then go collect on that judgment. So in this case, it looks like that's going to be set aside. And my guess is this will just be an ongoing lawsuit. And then they had some things to say about the victim and how he committed fraud on the court to get this judgment. Don Richard, September 10th of 2024. Again, we're getting more and more closer to today's date. Combs' attorney said, Mr. Combs is shocked and disappointed by this lawsuit, attempt to rewrite history. Don Richard has now manufactured a series of false claims in hopes of trying to get a payday, conveniently timed to coincide with her album release and her press tour of Miss Richard had such a negative experience with making the band and Danity Kane. She would not have chosen to continue working directly with Mr. Combs for dirty money, nor would she have returned for making of the band and Reboot in 2020, featured on the Love album last year. It's unfortunate, Miss Richards. So looks like they are responding to certain people they feel like they have more evidence against, right? And this is, again, we learn something every time the defense, every time Diddy says something, we learn what potential defenses can be. Clearly money grab, clearly lying, clearly cancel culture, clearly attacking the victims if they have any criminal activity in their past. We've learned all that. You can expect all that in the criminal cases. We're learning what some of his defenses are going to be. This is another one. If it was so bad, why did you continue working with me? Why did you continue getting on albums with me and using me to make money? If it was so bad, why did you keep doing that? It's another defense we can expect from P. Diddy and crew. Will the civil lawsuits be put on hold till after the criminal case like Karen Reed trial? So yeah, you can guarantee they ain't going to be getting P. Diddy's deposition. Whether or not they're going to be completely stayed, I don't know. That's going to be a case-by-case basis would be my guess. Gabby O'Donnell. Can't I sign an NDA and break all the unenforceable rules immediately because it's voidable anyways? So I would never tell you to break a legal document. But what I will say is if they're unenforceable, then it's going to be very difficult for anybody to do anything against you based on an unenforceable and void legal document. But what I have to say is that is a case-by-case basis, a document-by-document basis, an action-by-action basis. Not all NDAs are completely unenforceable. Trogger, Peter, I'm sure I should already know this, but will you please explain why there are no cameras allowed in federal court trials? Because federal court system does what it does. They do what they want to do. I don't like it. I wish they wouldn't, but it's how it's always been, and it's their prerogative, and nobody has done anything to change it, right? It would take like legislation to force them to do it at this point. Federal judges are appointed for life, so they're not really scared of being voted out of their seat because the public is not happy about the lack of transparency, which a lot of state court judges, we could make our voice heard by that. Can't do that in federal court. Big boy court. We've had cases and trials where I've been sitting there and they'll say, stop everything. Defense attorneys, defendant, leave. The prosecutors and the feds need to talk to the judge to tell them we have to do something this way or you can't hear this. It's like, what? That violates every right. Confrontation clause, defendant's right to a fair trial, right to counsel. What are you talking about? They're like, national security. And we get kicked out. It's like, okay, there's nothing you can do about it. It's just, this is the type of stuff that people need to realize how powerful government is, and to think that they can never be corrupt and never, have a cop or a judge or a prosecutor do something wrong. Same thing with a criminal defense attorney, right? Can do bad things. We just have to realize it is possible, and there is enough power to have some pretty big, conspiracies or fraud that takes place. Azam, Peter, you're so smart. I wish I could borrow your brain or a part of it for a month or two. It would help me in my classes. Haha, thanks. Well, I'm certainly glad I'm not taking any more classes. I was sick of school by the time law school and the bar were over. But thank you, Azam. Very kind. All right, let's look at a couple more. By the way, we're on case number 11. I think he summarized, or the person that wrote this article summarizes like 20 plus cases. This lawsuit was filed. It doesn't say when. Issue for summons. Legal team not responded. There's a couple other ones I want to talk about. Not responded. Filed September 27th. October 14th. Okay, even more recent. Plaintiff, the alleged victim, is fighting to keep his name anonymous. His attorney has asked the judge to maintain the client's anonymity over fear of violence and retribution for coming forward with his allegations. So this is going to be a common theme now when we get into the Jane Doe and John Does. Okay. Again, same thing, filed October 14th. So you can see it's like they draft a bunch, they file a bunch, they move forward on a bunch. Discovery is going to be due on a bunch. If they all get stayed, they all get stayed at similar times. There was one, another October 14th Doe. All right, here we go. She filed the documents asking to keep her name anonymous. District Court Judge Louis Lyman granted her request on October 16th, stating that the nature of the assault allegations was highly personal and that revealing her identity may lead to significant potential harmful attentions from media and the public. And this was in federal court in New York. So I want to show you that some judges are immediately filed on October 16th, judge allowed her to stay Jane Doe based on, specifically, it's going to be a case-by-case thing, the allegations and the potential harmful attention from the media and the public. So we kind of are starting to get our answer. We had a question. Are they going to be allowed to be Jane Doe? Because there's got to be fairness. The defense has to be able to respond. They have to be able to know who it is to prepare their defense. If somebody's lying, if they're going to attack the credibility of the victim, if they're going to say, why did you keep working with me? If they're going to say you have all these more crimes of moral turpitude where you've lied and we know about it and we want to present that evidence to the jury, maybe more difficult. Now, sometimes they can tell the defense with a confidentiality agreement and the judge can tell them it's sealed, gag order, can't tell anybody, but you're able to do some of your background checks on them. There are different ways to handle it, but I wanted you guys to see that it's happening in certain cases. They're allowed to stay Jane Doe or John Doe. Again, here we go. New York Federal Court granted John Doe's request. So it's not just Jane Doe's. John Doe's are getting them granted as well. All right, this one, October 16th, my birthday this year. Federal court filed. Attorney Tony Busby held a press conference on October 1st. We saw that he was filing 120. Eric Wolf said, as Mr. Combs' legal team has emphasized, he cannot address every meritless allegation that has become a reckless media circus. Strong words still, even as recent as after an October 16th lawsuit. October 20th. So now, here we go. New York Federal Court. That was, 20 days ago. This judge is asking for the alleged victim to file a request to receive permission to proceed anonymously by October 28th, or else he will dismiss the complaint. Now, not dismiss it with prejudice, but dismiss it without prejudice, and you got to slap your name on it. If he dismisses it because you don't have a good reason to be John Doe, you've got to refile it again with, your name on it. But it's interesting because some of the other judges granted it in 2 days. He gave this John Doe 8 days. I would expect, based on the other judges' rulings, prior to this judge's ruling, that if he provides adequate nature of the allegations and potential media harassment or damage that could come because of the public nature of this case, that it will also be granted. If it's denied, I would be interested as to why. Are the allegations not as bad, not as embarrassing, not as headline worthy? What would be a judge's reason after multiple other judges found it was necessary to keep them anonymous? Same thing. Needs you to file permission to be anonymous. All right. Another October 20th. Combs family issued this statement. For the past month has devastated our family. Many have judged both him and us based on accusations, conspiracy theories, and false narratives that have spiraled into absurdity on social media. We stand united, supporting you every step of the way. We hold on to the truth, knowing it will prevail, and nothing will break the strength of our family. We miss you and love you, Dad. So, it's an important thing to point out. Maybe I haven't said it enough. He's presumed innocent. This would be horrible if these were all lies, right? If, 20 plus, hundreds of people came forward, according to Tony Busby, thousands, came forward and said Diddy did this over 20 years. And if they were all false allegations, it would be horrible, life ruining, not just for him and his family. So we have to leave that as an option that could potentially be true. Seems like the evidence is starting to stack up against him, but we don't know yet. It hasn't been proven yet. Okay, October 22nd lawsuit. The judge said that this Jane Doe could move forward anonymously. October 28th, less than 2 weeks ago, ongoing, we get to case number 25. Ongoing, and again, another statement. The lawyer behind this lawsuit is interested in media attention rather than the truth. As is obvious from his constant press appearances, we know who he's talking about. 1-800 number. As we've seen before, Mr. Combs cannot respond to every new publicity stunt, even in response to the claims that are facially ridiculous or demonstrably false. Mr. Combs and his legal team have full confidence in the facts and the integrity of the judicial process in court. The truth will prevail that Mr. Combs never did these two things. Assaulted anybody or trafficked anyone. Man, woman, adult, or minor. Strong words. Wouldn't be the first time people are pounding their chest and later change the tune. But I will also say about 1-800 numbers and vanity numbers and billboards and press conferences and things like that, right? People hate those lawyers. There are some really bad lawyers that do that. There are some good lawyers that do that as well. It's not my favorite. It's not necessarily what I think the best form of like networking and advertising is, but I will say, it also doesn't make those lawyers wrong. It also doesn't make those lawyers have loser cases. Many of those lawyers have gone on to very successful, hundreds of millions of dollars of verdicts, settlements, even billions of dollars, proven that people and companies and businesses did things to severely injure, hurt, damage, or kill innocent victims. And just because Tony Busby has a 1-800 number, and again, Tony Busby's a big personality, he does things a certain way, right? Not everybody might agree with that way, but that doesn't mean the victims are lying. Just because they hired Tony Busby does not mean these victims are lying. It does not mean that P. Diddy didn't do it just because they hired a guy with a 1-800 number, right? John O'Rourke, I know, doesn't like that stuff. He says, yeah, it works. And I know you don't like it. And I get it, man. I hate a lot of the advertising. I hate a lot of the ego pumping. I hate a lot of it because it gives certain people a thought that is not reasonable about their case. Like they think, oh, you got $1 billion for this case. That means my case is worth $1 billion. And they try to sell you on that. And, it can be phony and fake. And you can, entice somebody to come sign with you under false pretenses because of a lot of that. There's a lot I don't like about it. But a 1-800 number, a press conference, getting yourself out there. Some could say the same about a YouTube channel, right? I'm sure that defense attorneys would say the same thing about a YouTube channel, ambulance chasers. Yes, I get it. And I get the reason for the stereotypes and the names and the lawyer jokes, and I get it. And lawyers have to have thick skin. I get it. But what I will say is some of the literal most successful lawyers who fight for injured and damaged victims have stuff like that. They have something to where there's a reason people know who they are. And they are not afraid usually of being called names publicly. They're not afraid of some defense lawyer saying this is a money grab, of some defense lawyer calling their client a liar. They just want the money. It's like, well, what your client did to them, sir, deserves a lot of money, more money than he has. It deserves worse than money. We'd like to do the same thing to your client, but that's not the type of society we live in, so that's why we ask for money. So KL said, Busby is not some billboard lawyer, is very esteemed and respect. So what I'll say is, the definition of some billboard lawyer, right? I didn't say he's some billboard lawyer. I said he has an 800 number. He likes to do press conferences. He likes to be out there. He likes to get his name and face in front of people. And there are people, there are jurors. I will just tell you, I've had it happen to me in jury selection. The last one busted a panel over it because they're like, we hate billboard lawyers and people on your side. I'm like, well, we don't have billboards, sir, but we do the same type of work as some billboard lawyers do. Do you think those are all frivolous claims? And they say yes. If you've ever done a commercial, a press conference, if you have a vanity number, like a 1-800 number, whatever it may be, we hate you. And defense lawyers saying, you must be a phony fake lawyer if you do that stuff. It's like, well, let's see what the evidence shows. Because I don't create the evidence, right? Tony Busby doesn't create the evidence. He presents it. And I was not saying that he's a bad lawyer because of it at all. I don't think that at all. I think there's usually a reason people rise to notoriety and get these big cases and get these big verdicts and get these big settlements. I don't think it's luck. I don't think it's fraud. There may be, I'm sure there have been fraudulent cases where people have made a lot of money, but that's my view of it. And I think Tony Busby is very successful, and I don't think you can trip, fall, and stumble into that. I think there's a lot of hard work and smarts that goes into it, which doesn't mean we all have to agree on every single thing each person says. But I think the shots taken at him are more of, we don't like him because, this and that. Not, he loses every case, right? Not, he's not going to be able to prove it. We'll see. Ashley said, can we talk about how I'm 10-0 in fantasy? We go up against each other this week. Yeah, my team is on the struggle bus. I'm pushing to make the playoffs and get lucky. Did Woody and Slink steal the show last night? You can save this till the end. Yeah, we were at the end and they did. It was amazing. It was amazing. It was so much fun to see him doing that. Especially Maverick. He loves it. He it's like his favorite thing. Brooke is so good. She does everything. Brooke literally does everything. Maverick is more choosy about what he likes to do, but it was amazing. It was so much fun. Thank you for asking, John. They did a play last night as part of a CYT program here in Clearwater, and it was Toy Story, and Maverick was Woody, and Brooke was Slinky, and it was awesome. I loved watching it. Got a bunch of pictures and videos and things like that. But this was a long one. I appreciate you guys for joining me. Make sure you hit the like button. Make sure you subscribe. Let me know what else you're watching and what else we can break down for you. Give us a follow on Twitter and Instagram, at Lawyer You Know on Twitter, at Tragos Law on Instagram. But till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.